incorporates some of the questions. It incorporates some of the questions that we've had, like, can somebody under 16 start a special disability trust, which I saw the other day. I hope this is not going to be death by PowerPoint. So I hope that it's going to be interactive and you can ask questions and all that, and we can stop and we can also skip some things that we don't like. General advice warning, don't sue me. This is general advice, and everyone is entitled to kind of ask questions, but also please don't act on this advice. This is just general in nature. Eligibility and concessions. All right, so let's talk about, first of all, let's talk about what is a special disability trust, right? And how many of them there are. Well, when I started working on special disability trust was 2009, and I called Centrelink to establish one, and they said, we usually see them in wills. We've not really seen too many of them around. I think there was like 30 in 2009, and I was already like working on these things. So in time, I think now there's about 300 or 400 in the country. So they're still fairly new. There's only a handful of accountants and financial planners who know how to deal with them. And also lawyers are getting more familiar. So it's great. But anyway, what are they? A trust is established to meet the reasonable care, accommodation, and the needs of the person with severe disabilities. One trust for one principal beneficiary, no more, no less. Now that's important because if you're establishing one inter vivos and one in the will, that's a problem, right? So you can't have two, you can only have one. And it delivers valuable social security concessions when the deed and administration comply. But there's one more thing that I think it does deliver on, which is the additional protection. Like if you're going to have somebody with a disability, they're vulnerable. So to have Centrelink oversee the mechanism and making sure that there is compliance to it makes parents feel better about the whole situation. Okay, and I say parents, I mean, I'm establishing one for my mum, so it can go the other way around. My mum's got MS, so I'm going to establish one for her. I've already got the eligibility criteria. I met all the eligible criteria, but I've got this house that I want to donate to her. And so it can work the other way around as well. Okay, so headline concessions as at 1st of July 2025, asset test, you can have up to $832,750 of accessible assets inside the trust that's not accessible. That does not count your primary place of residence. So you could have a $2 million house inside the special disability trust and $832,000 not counted. Now, is there a cap on how much you can have in the special disability trust? No, you can have $20 million, but only $832,750 is going to be exempt from Centrelink assessment. The income, however, is not assessed for Centrelink purposes. So imagine if you have a really high yielding rural property that's worth $832,000, but it's generating $90,000 worth of income because it's a warehouse. None of that $90,000 is counted as a income for Centrelink purposes. So really cool thing to note. And the tax is taxed at the beneficiary tax rate, not at the trust tax rate. So we don't actually have to make a distribution either to the beneficiary. So we can hold it inside. But what happens if you hold money inside the trust is that it goes up in value. And so then you start having some sort of assessment issues. By the way, the $832,750 figure, then you have the normal concession for Centrelink that you can have another $300,000 or something like that for an individual before they start reducing your pension. So the normal asset test apply. If you're not familiar, please have a look at asset and income test, and you will see that every person in Australia who's got a disability or is on the age pension is allowed to have a particular amount of money before they start reducing your pension. So it's that particular amount of money, that threshold, plus $832,000. So potentially $1.1 million is what you can have before it impacts Centrelink at all. Okay. You don't need to be receiving payment to be eligible for a special disability trust from Centrelink, but the eligibility is about meeting the severe disability definition. You should always get confirmation for eligibility before the trust can be recognized as an SDT. One of the things that I see here that is a common question, Tara, is people say to me, oh, I don't I'm working as a parent or whatever, I don't get any care allowance or care payment, and the beneficiary doesn't get anything either because they've got assets. Are they eligible? Well, it's a matter of disability. It's not a matter of actual asset income test eligibility. It's more of a disability eligibility.
And William, we've had a question come through from Kerry Ann. Is there a particular definition for severe disability? Is that somewhere that can be looked up?
Uh-huh. Yep. And so maybe we'll browse it together so we can see where we can find it. But yes. So eligibility. So we're getting into it right now. Eligibility for somebody age 16 and over. Impairment means disability support pension criteria. So what we use here is ADAT, Adult Disability Assessment Tool, and would qualify a carer for care payment or allowance, and no likelihood of working more than 7 hours a week at or above minimum wage. This is a problem. This is a problem for all of us people who are interested in this sort of thing, because if you have a look at the wording, and has no likelihood of working 7 hours a week at or above, this is a problem. Why? Because take Woolworths, for example. They used to employ a whole lot of people with disabilities, 5 hours, 6 hours a week, etc. Because of a push to not pay people less than the award, they're now getting paid at or above. But that doesn't mean that they have full capacity to work at or above. That is to say that it's more of a mechanism where Woolies feel good about itself, that it's not taking advantage of people with disabilities. It's a corporate thing, but it doesn't take into account the legislative criteria and
Can
how
you
that
hear me?
impacts people.
You,
Oh,
you,
yes, we can hear you. All right. Maybe put the mic on mute and we won't have to hear you. Okay, eligibility for under 16. I think this is a question that came up, didn't it? Who wrote it? I can't recall, but it was definitely on the group, Tara. Is that, somebody's under 16, can we establish a special disability trust? So I thought I'd put it there.
That was me.
Has
Appreciate it.
No problem. Has severe disability or severe medical condition. Carer has an intense rating under the disability care load assessment for a child. Treating health professional certifies care will be needed more than 6 months and will be provided by a specified number of people. And I've put the rule in there for you. It's Social Security Act, Section 38E of the disability that explains the disability care load assessment. And I've also put the policy reference guide for you. I don't know what the situation is that you're working with, but this is where what you'd need to do. Okay, are we good so far? So now let's talk about structuring. Create it, fund it, and reference it. Okay, when to create it, inter vivos or versus testamentary. We all know what that means, but inter vivos is basically when you want to do something productive, like usually anyway, a parent says, I'm getting too old, my child is getting too old, I don't want them to be staying with me forever. There's also transition planning. I'm really worried if something happens to me, if I need care, what's going to happen to them? Let me build their capacity. Let me enable them to live by themselves. They're in their 30s, maybe younger, maybe older. Can we buy them a place? Can we make sure that they have a place to live in? And the answer is yes. Have you got the resources to donate money? Because you can't get that money back. You can't just wind it up and say, no, you can't, there's only two ways you can wind up a trust, isn't it? There's when the money runs out or when the person dies. So you can't really gift money that you can't afford. So one of the big issues is, can I build a home? And if you do it properly, then you might also end up with a SDA, which is a special disability accommodation that you get extra rent from. We can explore that with your client. If you call me up one day and said, look, I've got the situation, we can then unpack that a little bit more to make sure that it's viable. Immediate family donors may access the $500,000 gifting concession. And we'll talk about that in next slides. Testamentary via will. Death obviously activates on death. Yeah. Yeah, so I've put there the planning issue. Like if you ask me from my point of view as a financial planner, will the donor have enough money to retire on? The desire to look after the loved one may be counterproductive to the overall family well-being. If you're depriving yourself of a good retirement, and you've locked up your money in a special disability trust, potentially nobody can benefit from it, including the person with a disability due to the restrictions of what the money can be spent on. So it's not always a good idea. Okay. How we have seen it referenced in a will. Tara, I think you probably need to vet this to make sure that it's appropriate. But this is just what I've seen. State the intention to establish a special disability trust for name that complies with Section 1209L and T of the Social Security Act 1991. Attach, incorporate the model deed, but also you can make reference to it as well. But Tara, I defer to you on this.
Yeah, so I actually think there's a couple of ways you can structure it. And I think it will depend on the level of certainty around the need for the special disability trust. And, if you're like, there's a possibility, but we're not sure, um, perhaps, and I think you might go into this, William, but sometimes the structure and compliance around a special disability trust can be too onerous, and the estate is large enough. So it just really depends on a host of factors. But the way that we train our TT Precedents Club members on it is, yeah, firstly, this option that you have set out. So we actually are using the model trust deed and incorporating that perhaps as an annexure where we are gifting directly to it. Alternatively, there is an ability for a beneficiary themselves to contribute within 3 years from the testator's death, the inheritance. And that can be a pathway as well where we're not sure or we just want to keep the option open. So especially when we're drafting like a testamentary trust will, we just have the ability to, if it's needed, sorry. Guys, just mute yourself, please. Who's that? Alice. All right. So then we have the ability to bypass the testamentary trust and have the inheritance go directly to that principal beneficiary so that it can be contributed into a special disability trust set up after the testator's death. Now, there's a whole host of issues there in terms of needing a financial administrator to go through that process. So that can sometimes be easy, sometimes challenging. And then also, if there's already a special disability trust established into Vivos, we can just gift straight into that as well. So we sort of talk about, there's multiple options, multiple ways to draft it, and pros and cons of each.
That's great, and I've seen it done. Like usually, people come to me after there is no reference in the will. The usual
Yeah.
is that there is no reference in the will. Then that's because, like, let's not forget, like special disability trust only became something in 2007. So a lot of the wills that have been drafted prior to that, there is no reference for a special disability trust, and that's why we've got this 3 years rule. Now that's from probate, and I think you can I'm pretty sure, isn't it, Tara?
Well, I've actually have not ever been sure. So I
Yeah.
feel like it's not completely clear.
Yeah, so it's an interesting one. I'm working on a couple at the moment for different with different colleagues, and it seems to be it's from date of probate, and also one particular case is really interesting where the money was distributed. It's gone under the New South Wales trustee and guardian. The parents are the appointed financial managers in this particular case, like NCAT awarded them financial management. But now we're writing to NCAT saying, the money shouldn't have been paid this way. It should have been done through a special disability trust. And of course, what these parents didn't do is they didn't inform Centrelink that there is $500,000 sitting in their daughter's account. She inherited money from a cousin. And we got a $63,000 bill from Centrelink for the past 4 years. But where the argument was that the lawyer put together is to enable us to donate into a special disability trust, is that the money didn't become available from the estate until about a year and a half after probate. So Centrelink also references when money can be assessed as an asset, and it's usually if it becomes available. So there's probate date. There's also when does it become available date, and I think that's where collaboration and also communication with different parties is going to be very helpful, because it seems to be a little bit discretionary. And Tara, I think that's why you're saying, is it this or is it that? We don't quite know 100%.
I just think, circumstances can
Right.
change in terms of even a beneficiary who is not disabled subsequently becomes disabled, like that we just didn't even know when the
That's a really
will
interesting
was
point.
drafted. And so there's lots of just, and, how big is the estate, and do we really need the Special Disability Trust to preserve Centrelink?
Exa
Because that's the main objective, right, William? Like usually it's to preserve the Centrelink
Yeah, it's tax
entitlements.
and it's
Otherwise, you
tax and
wouldn't
social
use.
security. It's tax and social
Yeah,
security effectively. You're trying to preserve wealth by deferring expenses onto Centrelink and preserve tax. Effectively, that's why you do it. But there's also that protective overlayer. So a lot of
yeah,
people say, if I die, I don't look, the cousin is the trustee, but I don't actually trust them. But they're the only
yeah.
people who are alive. I would love someone to look at them, what they're doing, to make sure that my son, daughter, etc., are not being done. Anyway.
Yeah, that's true. So I think it really depends. Like some families, they have so much wealth that they really don't want to cap what the beneficiary is entitled to, and they would have ordinarily received a much larger share than what can be put into the
Mm.
Special Disability Trust. Others, the Special Disability Trust is just a godsend because they need to, provide for their beneficiary with
Yep.
all of those protections, but still not jeopardize any of their Centrelink entitlements. So it's really hard to sort of have a one size
Mm.
fits all answer, I think.
And what else is the reason? It could be that the person, but look, I mean, from a Centrelink point of view, we've got three real tools, right? We've got a primary place of residence if we really wanted to make the money go away. We've got a special disability trust, and we've got superannuation if they're under 67. So if we can effectively inbuild that as a fallback to say that if it's a primary place of residence, maybe don't have it in a special disability trust, or maybe you do if there are stamp duty exemptions, for example, then it might be very helpful to have it in a special disability trust. But then you have to have cash and stuff like that to make sure that the trust is able to meet its obligations, pay the accountant, pay this, pay that, the setup fees. So it could be an expensive ongoing way to have a primary place of residence only for an upfront concession, potentially. Um, the other thing you can do is that if let's say that you've left $1.5 million for someone with a disability, so $800,000 can go into a special disability trust. $300,000 on top of that is not going to be counted for Centrelink, and then the remainder, say 360, can go into superannuation. You effectively made the entire $1.5 million go away. So that's a way. But you need that, especially in a will. You need those as fallback suggestions, tools, options. I don't know how you reference them, Tara, when it comes to wills. Um, Rules, governance, and compliance. This is fun. Lawyer's dream. At least two trustees acting jointly, unless there is a professional trustee is appointed. All must be Australian residents and not disqualified. You've got to do annual financial statements to the 30th of June, due by 31st of March. So when I'm talking to parents, I'm like, hey, you do realize that you have to find an accountant who is familiar with this, because not all accountants are familiar. And we've located a couple of really good accountants that do this for a living. You need to include a stat dec, and if required, the tax return. Now, I say if required, because what happens if the special disability trust is established on the 29th of June? And we still, no money's gone in yet. So it might not be required. Tax returns might not be required for that financial year. But you need to let Centrelink know that effectively it's just been established and there's no money in it yet. Audit can be requested by beneficiary, immediate family, guardian, administrator, or the secretary. Trustees must comply. Now, this is interesting because we do have a case at the moment where a friend who is really, really, really annoying of the family requested that, an audit be done because he promised the mother before her passing that he would look after her. Now he's not a trustee, he's got nothing to do with it. The siblings are the trustees, but he decided to basically request an audit, and so that's happening at the moment. So sometimes well-meaning people can utilize this too. Anyway, okay, what the trust can pay for. The primary purpose. So there is a primary purpose and a discretionary spending, primary spending. Care needs related to disability, medical, dental therapies, mobility aids. If you've seen some of my other presentations, we talked about food. Can food be paid? Well, if it's special food, that is to say that it's, for example, low-calorie food and it's requested by a dietitian, etc., then that goes under the primary purpose. If it's standard items, consumables, then it goes under the discretionary. So if there's a nexus between the expense and the disability, direct nexus, then it goes under primary. If there is no nexus, then we fall into the discretionary cap, which I'll tell you about now in a sec. Accommodation needs, buying or renting a home. So rent can be paid through the Special Disability Trust. Taxes, rates, maintenance, etc., can be paid through the Special Disability Trust. But it cannot pay for family members for care or services, and must use arm's length providers. Now, this is really interesting because some parents do end up establishing, like the package, the NDIS package is so large, it's $1 million, and they need to make it stretch because that's not even enough to care for somebody 24/7. So what they end up doing is establishing their own companies and register them as NDIS providers. And then the company would hire people, and then they would pay people. Can we pay extra from the Special Disability Trust for extra support? The answer is that's not arm's length, yeah. So and you've got to ask the family. I think when somebody comes through your doors and says, I want to set something like this up for my child or whatever, whoever, you might want to say to them, how are you setting up the care for NDIS? Did you set up your own company or are you using a third-party provider? If they're setting up their own company, you have to let them know that they cannot pay themselves from the Special Disability Trust or anything that their company has to do with. Okay. Discretionary spending. So 14,750, this goes up every year. It's indexed. Covers everyday lifestyle items, food, utilities, household items, clothing, non-disability therapies, recreation, vehicle running costs, etc. Okay. Keep receipts. You must keep receipts and disclose yearly financials. So just because it's called discretionary, it doesn't mean that you don't keep receipts. You still have to keep receipts. And if you want to know the Act reference, it's section 23(1), and it's got like a list of all the things that you can pay for from the discretionary items. I suggest like cigarettes and all that sort of stuff, and might not be a good idea to pay for from the trust. But that happens a lot, like especially with some people are, smoke quite a lot. Okay. Means testing, how the concessions work. Asset test, SDT set up assets up to 832,750 are exempt from the beneficiary. The home is exempt. Income test is exempt. Clear enough? I think we covered that. Gifting concessions, lifetime cap of $500,000 per principal beneficiary. Now, this is really important because it's not it's a lifetime cap on the principal beneficiary. Let me give you an example so you can kind of visualize it, right? There's 4 of us. There's a family who wants to put in money, and we're all almost at the age pension. So I'm 65, my siblings are 64, 63, 60, whatever, right? And we all want to get rid of money because we want to be eligible for the age pension together. So I want to put in 200,000, my brother wants to put 200,000, and so on. Now, if my brother beats me and puts $500,000 in, how much can I put in? Nothing, right? Um, well, I can, but it will be still counted as my asset for 5 years. Does that make sense to you? Because the Centrelink gifting rules work if you've given money within the last 5 years above the gifting concession cap, then it counts as yours. So for until the 5 years is up. So that's where the last point is. If
Yeah.
gifts are made within 5 years before the donor claims a pension, the concession may apply when they qualify.
And so,
So
William, that's only relevant for donors who do need Centrelink entitlements if they are not
yeah,
eligible. If they're never going to be eligible anyway because they're over the thresholds, then they can just ignore that.
if somebody is self-funded retiree and not
Yeah.
getting anything, then that's fine. But when does it
Okay.
actually
Yeah.
get when does it actually count? When does it matter? There's only one
Mm,
other area where it matters, is that if you're entering into aged care. Because
yes.
aged care is assessed, it means tested as well. So the more assets you have, the more aged care fees you pay, daily care fees and means tested fees and all that sort of stuff, right? So if you get rid of money by donating it to a disabled person within your household, then you're paying less aged care fees. If somebody has beaten you and is give like if the whole thing was established with a gift, you've got a problem.
Yeah. And I think that just demonstrates like how many moving parts
Yeah,
and
there are.
nuances to this and like the importance of involving a financial
Yeah,
advisor who knows
yeah.
what they're doing because of that future planning and thinking about all the different areas
Mm.
that we could trip up.
What I love about the whole aged care thing is that if mum and son who's got a disability are living together and they have, and mum suddenly finds herself in aged care, then we could potentially establish the special disability trust then to make sure that mum is not basically eroding her wealth that she intends to leave for son, daughter with a disability. And we can do that by establishing a special disability trust and accessing the $500,000 gifting concessions to reduce her accessible income. Now, on that, which is really important, is if there is a beneficiary who's got a disability who lives in the house, then the house might also enjoy some exemptions while the person with a disability lives in there from aged care testing, but that's a different presentation. Okay, investing and funding. I've put in there the relevant act for you, like the relevant sections of the law. Uh, so trust income is generally taxed at the principal beneficiary's margin tax rate, not as Section 991A rates, which is basically attributed back to the trustee, effectively, right? CGT, transfer of assets for no consideration, is disregarded. That's 80 AA 997, Section 118. 85, CGT main residence, and SDT can access the main residence exemption to the extent that the beneficiary lives in the home. There's also state-based concessions, stamp duty concessions, and all that sort of stuff that you've got to be mindful of on the donations. Oh, this is not very well formatted. Cash contributes directly to SDT. Moving money. How do we move money? Are you guys all right? Do you have any questions so far before we get into the financial side?
There's a lot of questions, William, but I'm wondering if you want to go through your slides or if you are happy to go on
I will
the
go fast. I'll go fast.
deviation of the questions.
I'll go fast. Okay. But
Yeah.
here is what you need to know about this, right? Don't sell your assets that you want to gift or you want to put in a special disability trust, including from an estate. Don't sell the estate assets that you want to Done. Let me give you an example. Right? Say that we've got an estate. It's got a bit of cash and it's got a bit of shares. And let's say that they're equivalent value. So $50,000 in cash, $50,000 worth of shares. If you sell everything, then you have to pay CGT on the shares, correct? So then the estate, instead of being worth $100,000, is now worth $90,000 because $10,000 is gone in tax, and then you divide it by two. So assuming that there's two beneficiaries, they get $45,000 each. Okay. Or you could do it this way. You could donate the $50,000 shares to the Special Disability Trust, then sell it. No CGT. The Special Disability Trust gets $50,000. And then you give the $50,000 cash to the person without a disability. What's the effect? You've just saved $10,000 of estate money. Okay, that's basically what this slide talks about. So don't sell assets that have CGT implications. If you've got provisions for a special disability trust, move them in specie into the special disability trust and then sell inside the special disability trust because you're resetting the cost base. Okay. Prudent investing. Everyone familiar with the prudent person investing rules? So under the Trustee Act in New South Wales, Section 14C and 14D, it basically tells you that you've got to diversify. You've got to give consideration to the duration of the and by the way, every state has effectively the same copy-paste trustee investment obligations. Okay, very good. Moving on. Common reasons and SDT eligibility is rejected. Insufficient evidence that the DSP level impairment is met. And there is no capacity for work more than 7 hours a week for work. Remember that a lot of people who are 16 years and over, they might not be on this disability pension just yet. So if they're already on a disability pension, then it should be fine. But then we have to evidence that they're not working more than 7 hours a week, or they have no capacity of working more than 7 hours a week at or below the award. For under 16s, carer not rated intense or health professional certification lacking, so that will get you declined. And then eligibility assessments are not obtained before establishing or funding the trust. That's really important. Good example of that is some really, really wealthy client came to me, has donated a $5 million property to his schizophrenic son. Centrelink wrote back saying that he's not eligible for a special disability trust. His lawyer and financial planner and accountant all were complicit in establishing the special disability trust before they got the eligibility letter from Centrelink. $5 million property. Then he gets a letter from, of course, Centrelink being Centrelink, he gets a letter from state revenue, etc., saying that you've got to pay all the stamp duty plus. So he thought that he was doing a smart thing by not paying stamps, right? He had to pay interest on that and then reverse the transaction and became what? An ordinary trust with with a lot of restrictions that doesn't enjoy any exemptions whatsoever. So they can't undo it because the deed is the deed. They can't undo the transaction, right? Because the deed is locks money in, but it doesn't do anything that they intended it to do. So now you've got a trust, you've got a place, you've got a house that's worth $5 million and nobody can do anything about it. They can't unwind it. They can't. Anyway, Tara, this is a
tough.
fun. It's a tough one. Yeah, I enjoyed working on that particular case. Not my heart was breaking, but I still enjoyed it.
Yeah. We've had a question come through that I think is related to that
Sure.
topic of the
Oh, sorry.
eligibility. So Jesse's asked, can you delve a bit further into the nuances of the eligibility rules around the likelihood of working at or above the minimum age? Is there any sort of high level?
Yeah, sure. I think we're here. So at or above the minimum wage? Yeah. They don't want let's not forget the history of the disability movement in Australia. So initially they were called sheltered workshops, And basically what these were, they were manufacturing places. They were workshops where people with disabilities were basically giving $1.50, $2 an hour to pack boxes and other things like that. That was supposed to engage them in the workplace. Centrelink disregarded a lot of their income, and they were getting, $10 a day, that kind of thing. It wasn't. Then as the momentum built in ensuring that the rights of people with disabilities are acknowledged, corporations started increasing that, like Woolies, Coles, all that. They do have, yeah, McDonald's, there's always somebody, at McDonald's will tell you how many people with disabilities they hire, people with Down syndrome, etc. The movement of paying them on par with their non-disabled colleagues picked up in the last few years. And what that ended up doing is that ended up um, giving them the minimum wage. So they no longer get the supported wage. So even in Fair Work Act, there, if you have a disability, there is a minimum that you get paid, but it's usually 30% less, something along those lines, of what somebody without a disability has. Some corporations voluntarily said, we're going to pay on par. We're going to pay the minimum wage. And that has created problems for eligibility. How do we counter that? Well, maybe they don't work for a while we are considering eligibility. So it becomes a planning process. My child is 16 years old. He's thinking of, working for the local McDonald's. We met with local McDonald's and they said that we would like to take him on at minimum wage. Yeah, don't do that just yet. Let's work on the eligibility. Does that give you a practical workaround? Okay. Don't deviate from the model deed, whatever you do. Implementation toolkit, practical setup. By the way, I'm racing through this because you'll have these slides. We'll send you these slides. So I'm interested in your questions rather than my own slides, okay? A practical setup checklists. First of all, obtain eligibility confirmation. Don't do anything without the eligibility confirmation. Otherwise, you end up like the guy with a $5 million problem. Adopt the model deed with compliance necessary variations. If Tara tells you vary it. If not, then don't. I'm just using Tara. But, if you exercise professional judgment. If it's I think the Tara, just tell me, I think they highlight in yellow what you can and can't vary. Correct?
Yes, and you really do need to stick to it. It's not the best drafted deed, to be honest, but Centrelink does not want to have lawyers reviewing it. They want to see that you have followed it exactly. So don't add your own flair, don't improve things. You really just have to follow their directions and then live with a deed that's a bit crappy. But, otherwise you'll get rejected. And I have learned that the hard way.
Yeah, and I think one of the things that my first lesson was the appointer has to have nothing, not the appointer. Well, I think appointer is really important, but I think, who was it? They can't sign anything. It was the
You do have, I mean, maybe this is a different point to what you're making, but you really have to be careful about
settler.
involving like the financial advisor as the settlor or
That's right.
anything
That's
because
right. It's the settler.
you cannot have any kind of remuneration. So it's actually can be kind of tricky to find a settlor because they can't have been paid at all.
Or have anything
So
to do with it. Yeah.
yeah, like when I've set them up, I've had to like rope in my spouse to be the settlor because because when you've got the financial advisor, the accountant, the lawyer, they've all, received remuneration. And then it's hard to get like a layperson to
Yeah.
understand what being a settlor is. So, yeah, just be careful of that.
I agree. That's what I was looking for. The settler is what I
Yeah.
had a problem with. We got the neighbor to be the settler in the end.
Yeah.
But it was rejected. The special civil trust was rejected on the basis that the settler couldn't be somebody that had anything to do with the trust, and it was the backup trustee, in fact. So the the big thing out of this is just follow the guidelines and you'll be fine. I think the issue about corporate trustee versus not, I think is also important for succession considerations, etc. But if you try to open up a bank account for a special disability trust or an investment account, good luck. We've tried, and we now work directly with the estate team at different banks to help them understand how to comply with their AML CTF obligations, because they want to identify the beneficiary, they want to identify the source of money, and they don't have a concept that this is the beneficiary is, for example, under legal disability, so they might not have an ID. So the actual implementation side is exhaustive. Not only dealing with Centrelink and their systems, but you're also dealing with the banking system that has not seen a lot of these. But lucky, my firm has got really good contacts now with the multiple banks to basically get this through the line, and we've got direct contacts with different people at different levels to assist. Okay. How do you name the trust? My favorite is name and special disability trust, because then we know what we're dealing with, and there could be an all needs protective trust and all that. So just give it the name so that everybody knows like how to even do the accounting for it and all that sort of stuff. Like it's just so much better than just writing, William John's Trust. Just tell us what it is. Empower the executor to establish the SDT using the model deed. If you don't, then that's okay, I guess. We have that timeline where we can do that. Authorize the transfer of the estate assets to the SDT, including direction for superannuation proceeds via estate where appropriate, and set the residual beneficiaries on the beneficiary's death, so we know where the money is going to go after. Okay. I'm going to skip this. Yeah, this is good. Can compensation money that the beneficiary has received, can it go into a special disability trust? Well, it's very basic. It's like a charity trust, charitable trust. You can't donate to yourself. Fair enough? Person's own money cannot be donated into the trust itself to reduce because it would have an effect of reducing their own assets and get more Centrelink. So cannot donate own money. You cannot direct the court to pay into a special disability trust where there's compensation, for example, for the beneficiary. Okay. Any payment to or dealing with immediate family risks non-compliance. Don't pay any, and there's one exemption, is that if someone lives with you in your house that's owned by a special disability trust, but they're in a carer role, but they could be a family member. Record keeping matters. You've got to keep your receipts. Otherwise, you face problems with Centrelink, and Centrelink does come and say, give us receipts. Build an annual trust health check. Eligibility, deed compliance, investment review. So we do that every 6 months. We have an investment review. We go through the Trustee Act requirements, and we tick the boxes saying, yes, we comply, we comply, we comply. Only one SDT per beneficiary. We said that. There is no cap of how much an SDT can hold. Only the concessional asset threshold for the means test. So you can have $20 million in there, but don't expect Centrelink to not count anything over the threshold, concessional threshold.
William, can I just interject for a few things there?
Yeah.
Can you confirm, someone has asked, can you have more than one special disability, sorry, more than one beneficiary of a special disability trust? So the answer is no.
No.
No. Where does the assets go? So you've just said that here, the assets vest. So I put the link in the chat to the model trust deed, and you'll see there's actually a schedule where you set it up about where the assets go on the beneficiary's death so that you can do that future planning. Can I also just interject when you said, a beneficiary can't contribute to the special disability trust? There are two exemptions
Tell me.
and I think you know this 1209R of the Social Security Act. It says the assets of the trust must not include any trust any asset transferred to the trust by the principal beneficiary of the trust or their partner, unless it's part of a bequest or
Yes.
a superannuation death benefit, and you
Yes.
have to contribute it for
I-
3 years. So
that's true.
that's, yeah. So
Yeah.
just to confirm, if we're like, oh, but you said we can't put it in, that's the only exemption. So super death benefit or bequest, and you've got the 3 years. So go and have a
Yeah,
look
within
at,
the 3 years. That's right.
yeah. So, like, have a look at the Social Security Act, people who are sort of curious and asking questions under Part 3.1A, 3.18A, because it sets it out really clearly what's allowed and not allowed. It's a very easy sort of section of legislation to follow. And it does, like, there's obviously so many nuances that William's talking about us today, but for the core stuff, just go to the source in the Social Security
I
Act.
agree. I agree. And let me just confirm what you said, because I think it's such an important point. If it's coming from somebody else, that is to say that it's coming from a superannuation death benefit, it's coming from a bequest in a will, etc., that is not my money. Do you remember how I gave you that example where I said to you, there's $500,000 and this lady, we're trying to unwind that and it come from the cousin? The money is in her name now, right? And Centrelink has already penalized her about $63,000 for being overpaid for the last few years. But what we're trying to do now is, because the origin of the money has come from the cousin, it's a bequest. We're trying to trigger that 3-year rule to put the money now in the special disability trust. Um, but for the time being, where the money was in her name, Centrelink, I don't think we can do anything about. We'll just have to, um, you know, we just have to say sorry and hope that there are no penalties associated with a non-disclosure. Um, so you're absolutely right. Key resources, some guides there, model deed and deed of variation forms. Now, just remember that the Special Disability Trust has been changed twice, I think 2011 and 2017 or 16. I can't recall. They're like small variations. And so sometimes you have to go back to your lawyer to update the model deed that you've put together. Um,
William, can I just ask you? I've always found that publication, Special Disability Trusts Getting Things Sorted, as a helpful resource, both for me and for clients. Do you rate that booklet or,
yeah, I think so. I think for
yeah,
human consumption for clients, it could be a bit full on, especially if you've got aging population.
yeah,
So, the, but I think it's a good start to
okay.
any good discussion. I didn't put it there, did I? I should have put it there. But yeah, I think
I'll put the link in the chat
yeah,
now. I just sort of found like when I first started wrapping my head around them, it does answer a lot of the sort of
it
preliminary
does.
questions
It
that
does.
I think are being asked in the chat here.
Yeah, I agree. And then that's my details. Okay. So now I'm happy to let's have a discussion. Let's have a human discussion. Hey.
Okay, we might I'll just call out I think the questions. So we've had a few questions about the home. So with the principal place of residence, including do you have to purchase one or can the funds in the principal place in the trust be used to purchase a principal place of residence? And then also uh, an extension of that is about, well, what happens when the residence needs to change and the cap and the limits there in terms of its, they bought a residence, it then needed to be, or the beneficiary moved out because it wasn't suitable any longer, and does it lose the exemption? Are they suddenly over the cap? Can you just sort of talk generally about how to navigate the residence? Sorry if that's too many questions at once. I can break it
Well,
down.
yeah, break it down for me.
Okay, so can you can both purchase a residence, like transfer a residence into the trust, and then
Yes.
you can also use like cash that's been transferred into the trust to purchase a
Yes.
principal place of residence. Those are
Yes.
both allowed.
Yes.
Um, do people run into problems when there is a residence, a principal place of residence, so that is being exempt in terms of the Centrelink asset limit, but then the beneficiary can no longer live in that and they might go
Oh,
into care
ah,
and
it's a very
suddenly
good
are
question.
people over the limit
It's
or
a it's a very good question. It's a very good question, in fact. And in fact, I will complicate it for you in a second, but I'll tell you this, is that uh, if they haven't got a second primary place of residence, then we can have it exempt for as long as possible. Centrelink gives you general exemption guidelines, 1 year off the bat, um, another year if we beg. Uh, in this case, we may be able to persuade them to apply the aged care um, exemptions. So we get a few months. Um, it does become an asset after a while. And it wouldn't be prudent, by the way, for a trustee to have an empty home there. So you if you look at it from a trustee investment point of view, it's no longer they're in care. You've got to rent out the property because what are you doing otherwise? Are you trying to maximize capital gains, or are you trying to serve the person who you're supposed to be looking after by making sure that there is income coming in to serve their needs? So um, let's say that we maximize the Centrelink exemptions. Once it becomes a rental property, then those exemptions lapse. Does that help you understand that there is a way, call it a year of exemption safely, and then uh, anything beyond that, once it becomes a rental property, then we lose the exemption, which means that it becomes an asset of the trust. So let's say that you've got $500,000, $600,000 in cash or shares or whatever, plus a primary place of residence, another $500,000. Now your trust is worth 1.1, $1.2 million. It could still, in the aggregate, fall under the Centrelink threshold of doing something about it or reducing your pension.
in terms that was a great answer. Thank you, William. And in terms of managing or monitoring the values of assets in the trust and meeting those limits, who's responsible for that? Is it does Centrelink audit it and work out like what happens if you're kind of up to the limit and then the capital growth means you've gone over?
Yeah, so every year, Centrelink will review like I said to you, on 30th of June, you've got to do the accounts and you've got to submit them to Centrelink on the 31st of March. It would be very silly to push it all the way to the 31st of March when you know that you're now exceeding the assets cap. So you want to do, come 30th of June, you want to get the accounting done and you want to submit it to Centrelink as soon as possible so Centrelink can do the adjustment. Because if you send it on the 31st of March, Centrelink will come back and say to you, listen, you've been over the cap for the last 6 months. We want our money back.
And so how do you divest the trust of
You can't.
asset? Yeah. So
You,
you really, so for lawyers, even, often it's tempting to be like, I'm going to gift to the Special Disability Trust an amount equal to the current cap at the date of the testator's death. And we're pushing it right to the limit. And then there's really no like leeway
I
for
can tell you
capital
this.
growth
I,
or.
I, I can tell you this. I can tell you this. We've got probably Australia's largest number of special disability trusts under management. So we advise a lot on this. The, um, the significant money that they end up having will blow your mind. There is because we NDIS funds everything these days, right? So we're not exactly depleting the money. The investment returns, if invested prudently, you're making at 5, 10%, 15% compound, depends on, because we've got to give regard to the duration of the trust. If somebody is in their 30s, 40s, they could live another 40 years. What am I doing holding so much cash in a special disability trust, given regard to, so I've got to think about that. And I've got to say, well, actually, you've got to go into a higher risk profile because we've got the time and to invest prudently. And holding so much cash is not going to be a prudent investment. Suddenly you start with $500,000, becomes 600, becomes a million, becomes $1.5 million in the span of 10 years. And you think, are we going to spend any money? What am I going to spend money on? Then you guys are spending on this and spending on that. So it becomes an education piece for the for the family to say, listen, start spending the money. And even when you spend money, 10, 20, $30,000, if you're returning 60, 70, $80,000 a year, it's going to compound really quickly. Some people say, well, I'm just not going to give anything to a person with a disability because I don't want I don't want their pension to be impacted. I don't think that's right.
Yeah. William, thank you so much. We are at the end of the hour, and I do have to run actually to our TT Precedents Club hot seat. So, TT
Sure.
Precedents Club members, we can keep this conversation going over there. But thank you so much for being so generous with your knowledge today. I think it's clear that no one in Australia knows more about special disability trusts than you.
You. Thank you.
We've had a lot of questions that we haven't been able to get to, and some of them have been very particular. So I really think for the people who have live matters or very particular matters, you've got William's contact
Yeah,
details.
look, I'll put them
Um,
on. I'll put them on for a sec. So just grab my
yeah,
email and then send me the issue that you've got, the question maybe even.
yeah,
William at healthfinance.com.au.
that's right. Engage him for proper advice, because I think as we can see here, the risks, the complexity of setting up these structures and understanding all of the moving parts is really high. Collaboration is key, and I think collaborating early as well and getting somebody who is experienced. And I'm especially talking from a lawyer's perspective. There's so much that we just do not have knowledge for or insurance for. And setting these up have long-term consequences from both estate planning, aged care planning, and just general, financial well-being of the donor and the beneficiary. So it is really important to collaborate and, plan do get the advice early and upfront so that you don't run into any issues like that horror story William mentioned. So we'll wrap it up. The replay will be up on the YouTube channel. We'll also get this as an episode on the Art of Estate Planning podcast, so you can have another listen and share it with people who you think would be interested as well. Thanks so much for joining in, everybody. A huge thank you again to William, and we will
Very
see you
welcome.
all next month. Take
Thanks,
care.
Sarah. Bye.